We're ready. Go ahead, Jim.
Good evening. I'd like to welcome you to the special session of the Bethlehem Zoning Hearing Board. My name is Jim Shantz. I'm acting as chair for this portion of the hearing. Serving with me on the board this evening are Terry Novotny, attorney Linda Shea Gardner. Legal counsel tonight is being given by Eric Schock. Our zoning officer is Craig Pfeiffer, and Ms. Jean Genova is going to be our court stenographer. Since tonight is unique, we're starting at 5 o'clock and it had been advertised. We only have one hearing that is under determination at this time, and that's the continuation of the validity challenge for 2 West Market Street. At this point, I'm going to turn it over to Attorney Schock to run the meeting.
Thank you, Mr. Shantz. So I just want to put on the record that as was requested by the board, instead of having lengthy oral argument, we asked for the parties to submit findings of fact and brief conclusions of law, however they wanted to characterize it. The record should reflect that Mr. Stevens timely submitted his, the city and the interveners timely submitted theirs, and I will confirm all of the board members have received those and have had the opportunity to review them, correct?
Yes.
Okay. So with that, what we had indicated at our last meeting is, Mr. Stevens, you went first. Intervener and city had an opportunity to respond. We'd say, can you take a few minutes if you'd like, no more than 5 if you can keep it to that, to respond to anything that they raised in their response to yours. And then if there's anything that you discussed that they want to respond to, we'd let the city and the intervener do that. But there is absolutely no need, and we would stop you to rehash what all of you gentlemen submitted in this very thick pile of paper that I have in front of me.
Okay.
Great.
Thank you, and may it please the Zoning Hearing Board. And at first, I just want to thank the Zoning Hearing Board for your time, your patience, and your consideration through the multiple hearings that we've had, as well as reviewing the briefs that have been submitted by the parties. As you're aware, I represent the appellants, but it's just not just the appellants, it's also the individuals who came forward and expressed their opposition to this amendment at the time of the public hearings, as well as those other people who are impacted by this amendment who may not be aware of it, which is one of the key issues in our position in opposing this. And by order of the issues, one of the key issues is the fact that there never was done proper due diligence and study of this particular zoning amendment. We don't know the definitive numbers, nor how this amendment will impact the residents in the RT and RG districts and overall in the city of Bethlehem. And that is a key threshold issue. We would submit that the zoning amendment does not sufficiently articulate how it promotes the health and general safety and welfare of the citizens of Bethlehem. And there are 3 cases I want to discuss that were in the briefs of the city as well as the applicant that are significant in your analysis. The first one, there was quite a bit of time spent in the briefs on the Baker case, but I just want to point out key factors in what should be in your analysis of that case. In the Baker case, the zoning hearing board was overturned by the trial court, and that was affirmed by the higher court. And the analysis was really looking at 4 different main factors. The first was the failure to provide full and fair examination of the impact which the rezoning would have, which is the key issue that we've been really discussing. In this case, we have testimony of Darlene Heller, our expert, the opposing expert, that clearly states, and it's unrebutted, that the ultimate impact of this amendment remains unclear. We don't know the number of eligible properties that are affected by it. There also was a factor of the concern for the expedited deliberation process to the detriment of the public interest. Again, there's facts for you to consider that as far as the request by Dr. Van Wert to request data and analyze that data and determine the impact. Well, that never happened. The data was provided, but the analysis was never occurred because it was produced on the day of the last vote by City Council. So that analysis and the impact never did occur. So there was that issue in Baker. We have it in our circumstances. The third factor was the failure to submit the plan to the County Planning Commission. Now, the city, in their brief, spends a lot of time saying, well, this is a procedural distinction. They procedurally in Baker did not submit the plan to the Planning Commission. And that's what happened. Yes, that was a factor. In our case, we would submit that it's even stronger in our case because yes, the procedural measures were followed and the amendment was submitted to the Bethlehem Planning Commission. But what did the Bethlehem Planning Commission do? They said this should be voted down. We are concerned because the impact of the amendment has never been determined and therefore it should be voted down. So that whole procedural argument that you'll see in the briefs we submit, it's stronger in our case because the Planning Commission has told both Zoning Council and you as the reviewing board of City Council that there's concerns here. We don't know what the impact is. The fourth point was in Baker, they asked that a third-party expert under their circumstances should review the impact. We'd submit the same should apply here. There was an attempt by Mr. Bannock, but what did we learn from Mr. Bannock's testimony? We learned that he simply was not sure, was unclear what the impact was. The 8 properties they looked at, that still was an indefinite number. The next case is the Kendry case, and that's what I've submitted through council. There was argument.
And I handed it out to each person.
There was
just so you
argument
know.
in the city's brief as well as the applicant that there's no law to support what I've just expressed to the zoning hearing panel. That the key issue of whether or not there's been a failure to properly assess the impact of a zoning amendment, whether or not that's sufficient grounds to overturn it. The Kendry case had those particular facts, and it was similar. You can read the case. It was a zoning amendment where they were changing from residential to a administrative research. Essentially, they were taking an insurance company owned land and they were trying to convert it and essentially put in administrative and office use into residential land. And in that case, they simply didn't do any kind of impact study. And that was the ground that they overturned the zoning amendment in the Kendry case. So there is law that's out there on this very issue, and it's before the panel, before the zoning hearing board. The third case was cited in our brief, but I handed up the case because I think it's really significant and should be read. And I don't think it was addressed in the city's briefing. It's the French case versus zoning hearing board. It's a Pennsylvania Supreme Court case. There, a zoning ordinance was adopted in the city of Philadelphia that was over a 10-block area, and there were these pockets of 6 different properties that were commercial properties. In that case, the court found that to be an invalid zoning ordinance because the commercial properties were essentially spot zoning. And it goes to their argument that, oh, you can just have one property and only one property alone would be spot zoning. No, there's case law to show where you zone in an area and then there's 6 different properties that are commercial properties that in fact can be deemed spot zoning. The other significance of this case goes to the non-conforming argument in that there it really was like a backdoor. You had non-conforming commercial uses within that residential district. They tried to rezone over it to basically authorize that non-conforming use, and the court said, no, you can't zone over that. I mean, they're non-conforming uses. You have to follow the law of non-conforming uses 1323, which is an argument that we put throughout the brief, and we would submit that the French case applies to that 1323 argument as well. Other than that, I have nothing more for the zoning hearing board. And again, thank you for your time and consideration of the appellant's challenge to the zoning amendment. Thank you.
Thank you. Perfectly. That's what we wanted. Do you guys have any of those items that you want to touch on that Mr. Stevens just mentioned?
Yes. Can you hear? Is this working?
Yep.
Yes, thank you.
Okay. Yeah. It's a little like law school. I'm giving a hypothetical in real time, real cases, and you have to try to figure out what's going on. As far as the first case that you said that Mr. Stevens said was in his brief, I believe that we've addressed that, the Baker case, and I would point you to the discussion that's in my colleague's brief, Attorney Deschler. I think he handled that very well. I'm not going to go into that anymore. We have 2 new cases here that I'm seeing here for the first time tonight, and I'm noticing a couple of things here. They're talking about in the Let's take the first case, which is the Zoning Board of Adjustment and Harry J. Bogash. I see that this is a 1962 case from 1962. It's from the city of Philadelphia. I don't know if any of you were around back then, but this is before the MPC, which was adopted in 1968. This talks about reliance on the comprehensive plan. Apparently, their zoning was a function of the authority of the First Class Zoning Enabling Act of 1929. This was all displaced and replaced by the MPC, which was adopted in 1968. And of course, the MPC speaks directly to the reliance on the comprehensive plan and the fact that, as has been stated in the briefs, I quote, "Notwithstanding any other provision of this act, no action by the governing body of a municipality shall be invalid, nor shall the same be subject to challenge or appeal on the basis that such action is inconsistent with or fails to comply with a provision of the comprehensive plan." Now, that rule comes after this case. This case was decided before that, and this is based on a separate enabling legislation. My brief read of it, which is all I have the opportunity to do now, is it appears that the court found this defective because they didn't spend enough time matching this up to the comprehensive plan, which they probably had to do back in 1962. The second case, which is Kendry et al. Versus White Marsh, this looks like a common pleas case out of the Montgomery County Law Reporter. This is even a little older. This is from 1962. Same process here. This predates the MPC. I believe the MPC sort of changed the landscape a little bit on how to apply zoning law, what constitutes a valid zoning amendment and what does not. This, again, the ordinances in this case come from or were adopted pursuant to the second-class township code. And again, that's because the MPC had not been adopted or enacted at that time. Appellants, I'm reading here, point to section 203 of the second-class township code, which requires that all regulations shall be made in accordance with a comprehensive plan, and so forth. I think that the law in these two cases is probably not applicable, giving my brief read, giving the dating of the cases, given what I'm seeing as the holding in those cases. I don't think they really pertain to what's in front of us. And again, the third case, which is Baker's case, I think I'll just rely on the briefs for that.
Okay. Anything to add, Mr. Deschler?
Yes. Let's see. First off, with regard to the Kendry versus White Marsh Township case, I will wholly associate myself with the beginning of the first full paragraph on the last page of that opinion, where it notes that in our opinion, the Supreme Court, by the Eves decision, did not state or intend to state that a zoning amendment is invalid simply because it originated from the application of a single owner of property. Now, moving on to some of the other points raised tonight regarding a lack of study about the impact of 1304.04B. Again, what I find interesting is that the very gold star amendment at 1304.04A that the challengers praise so highly was not subject to what it seems like they think is required, a rigorous, comprehensive analysis as to its precise impact. And I think that's a question we need to ask ourselves, and because the challengers haven't put on evidence as to what sort of study they believe would satisfy validity requirements. We haven't heard evidence about that, and I would submit that it's their burden to show what that sort of study would look like, because we are not talking here about a set of facts similar to the cases presented tonight or in Mr. Stevens' brief, where you have a discrete tract of land or discrete tracts of land affected by an amendment. This is adding an additional low-impact office use to a property on which there is already present a low-impact office use or retail use. I think if one looks at the impact in that fashion, that we are simply potentially adding a similar low-impact use, a use that's similar to a use already in the property, I think the board can divine from that this amendment is not going to have a dramatic impact on the residents of the city. And I think you can look at and find that it is rationally related to to promoting the health, safety, welfare, morals of the city by looking at the end result. Mr. Stevens wants to make a big deal about the process that led to it. A process that, as he acknowledges, was procedurally in compliance with the MPC. Mr. Stevens' clients don't like the result. That is not a ground to invalidate the ordinance amendment. If we look at the actual end result, right, as I've laid on my brief, how this ordinance is and does relate to the comprehensive plan, we can all pick out perhaps points where the comprehensive plan might support or maybe it would not support the enactment of this ordinance. We could all do that, but that's not the point. It's not as if this ordinance has to comply or advance. It does comply with, but it doesn't have to advance every single point in the comprehensive plan. What's relevant is that there are multiple provisions in the comprehensive plan that are advanced by the enactment of the ordinance. I think, and once the city demonstrates that, I think we're in a position where we have rebutted any attempt by Mr. Stevens to prove that there is no rational relation to the promotion of the health, welfare, safety, morals of the citizens of Bethlehem. So I think when we look at the comprehensive plan, how those provisions are advanced by this ordinance, you can see that this is reasonably related to the promotion of the health, welfare, safety, morals of the city. Just because the challengers don't like the outcome of this ordinance does not mean it's substantively invalid. Just because we cannot divine to a mathematical certainty the impact of this ordinance and to how many properties will apply to does not mean it's substantively invalid. The challengers have presented no cases that would indicate a position contrary to what I've just said. So with that, I thank the board for its time, and I would ask that you uphold the validity of the ordinance.
All right. Thank you very much, gentlemen. And we will adjourn to deliberate, correct? Okay.
I'll follow you up.
No,
No.
I don't.
That's coming up. I would say it's not a bad neighbor. I have no problem with it, but I just, they're parking spots. I just want to hear what they're saying. Yeah. Probably a good thing. He would have had a definite opinion. Just before the mob. If you're driving. Get my message.
You didn't want me to call you back, did you?
You don't need
He never called.
No, it's easy.
Ted never called.
Okay.
So, but Karen's coming.
Okay.
But then Ted ran into Karen today and then Ted emails me and he's like,
Parking lot's full.
I know I got some, but I'm like, no, you didn't.
Some of the guys down at
So, but you're all good.
Okay. Yeah, I mean, because
I remember about the old.
now the fees, are they required now, or at least encouraged to go through the court reporters at the courthouse?
I'll talk to you in about
Okay.
1 second.
But I really love to show you photos of the inside. Figure out a place to go.
Mm-mm. Is Mary Frances a regular member tonight? She an alternate?
She's an alternate. She's filling out one.
Do you know which one?
I think it's gonna be the judge.
All right, so is Pete coming tonight?
Yes. It's my understanding, and Terry Fall will be solicitor. Did you get Craig's emails? Oh. I asked Terry for. I guess he's going to discuss that.
Stone. I gotta get myself organized here. 6:30? I forgot.
Yeah, Jim wanted to make sure it was adequate time for me to discuss
These other ones. Are these.
I don't know. Oh, I'm sorry. For a date. Forgive me, I've read them.
Yeah. Oh, we got a good date.
They've got a little bit more sensitive effect. Thanks for the comment.
Thank you.
Yeah, I just mean. I defer to the, so whoever they have. Okay. That doesn't make sense. The work should be funded. Workhouse. That way you know. First way. I guess it's like different. Right. As long as you turn to the left, just work your way up. Yeah, that's right. I do. Yeah, we have. Office there. That's the drive. I'd rather. Sometimes it's. What are they talking?
Gene, you ready? We'd like to go back on the record now. Before I ask for a vote, I'd like to thank everybody that's been involved with this hearing. It's been we're in our 8th night now. We're at roughly about 22 hours into the hearing. I'd like to thank council for the job that I think everybody's done a great job in their presentations. I'd like to thank all the witnesses that have appeared before us. I'd like to thank all 3 councils for the job that they've done. They've done an admirable job. I'd like to thank my fellow board members as well too, our solicitor and our 2 stenographers, and of course, Mr. Pfeiffer. At this moment, I'd like to take a motion.
I'd make a motion to deny the appeal and uphold the validity of the zoning amendment.
I second.
Mr. Novatnik,
Yes.
Ms. Gardner,
Yes.
Mr. Shantz.
Yes.
Okay. You'll get a decision within 45 days from tonight. Hey, thanks.
And this hearing is adjourned.
Mr. Chairman, we're not going to thank the,
Oh, my apologies.
right now our feelings are hurt. So loyally sat by
I realize that. My apologies.